SNAP benefits. A lot has happened in the past week in the fight between the Trump administration and the courts over SNAP benefits. As far as I can tell, benefits have still not been paid from the federal government to the states. States are taking different measures, some paying benefits out of state funds, some moving money around to pay partial benefits, and some not paying benefits at all. Now, the United States Court of Appeals for the First Circuit has issued a scathing rebuke of the Trump administration for withholding benefits for political leverage. But before we review that, let's briefly discuss how we got here because, oh boy, it's a doozy. SNAP benefits are important. Companies in the United States have a history of underpaying their workers. These are not people who are lazy and leeching off the system. These are people who are working and simply aren't paid enough to live, aren't paid a living wage, and therefore the government must subsidize their food to help them have enough to survive. But with the government shut down, the Trump administration has chosen to withhold and not pay SNAP benefits, instead starving the country's most vulnerable people as political leverage, as a bargaining chip, to attempt to get some kind of capitulation from the opposing party, the Democrats. In my previous video, I went over an earlier decision by Judge McConnell of the District of Rhode Island in a case brought by the Rhode Island Council of Churches, among many others, where he said that SNAP benefits would have to go out, would have to be paid, and it was just a matter of figuring out which financial vehicle the government would use to get there. But things have escalated since then and quickly, and Judge McConnell has now sternly rebuked the Trump administration and its attempts to starve its citizens for political gain. The Rhode Island case. After initially giving the Trump administration more time to figure out which source of funds they would use to pay SNAP benefits, Judge McConnell ran out of patience on Thursday of last week when he learned Trump was still delaying the paying of benefits, and bragging about it on social media. Within an hour of the plaintiffs filing their motion, the president issued another social media post in which he stated that SNAP benefits, which increased by billions and billions of dollars manyfold during crooked Joe Biden's disastrous term in office, due to the fact that they were haphazardly handed to anyone for the asking, as opposed to just those in need, which is the purpose of SNAP, will be given only when the radical left Democrats open up the government, which they can easily do, and not before. Thank you for your attention to this matter. While the President of the United States professes a commitment to helping those it serves, the government's actions tell a different story. Faced with a choice between advancing relief and entrenching delay, it chose the latter, an outcome that predictably magnifies harm and undermines the very purpose of the program it administers. Such conduct is more than poor judgment, it is arbitrary and capricious. One cannot champion the public interest while simultaneously adopting policies that frustrate it. Discretion exercised in this manner ceases to be discretion at all. It becomes obstruction, cloaked in administrative formality. Accordingly, intervention is not only warranted, but necessary to restore coherence, accountability, and fidelity to the law's intent. The defendants overlook the fundamental point that compliance is achieved when Americans are fed. The court is not inclined to excuse this noncompliance, particularly where the obstacles the defendants now invoke are the foreseeable result of their own choices. The court finds it astounding that the defendants would even choose to go down this path if they were aware of all the difficulties and delays that such partial payment of SNAP benefits would entail. What then of the tens of millions of Americans who rely on the SNAP program? Nowhere in its decision did the USDA consider the increased harm that will befall these recipients if they are forced to go without food for a few weeks up to several months. This is precisely the irreparable harm that the court contemplated when it issued its TRO, which is why the defendants were required to act expeditiously. Providing a pretextual reason for taking agency action that is incongruent with what the record reveals about the agency's priorities and decision-making process can be a basis for setting aside agency action as arbitrary and capricious. Courts are not required to exhibit a naivete from which ordinary citizens are free, and they must ensure that agencies offer genuine justifications for important decisions. The real reason USDA chose not to fully fund SNAP was for partisan political purposes. As a prime example, the banner on the USDA's website, which beginning on or about October 27th, 2025, provided that, quote, the well has run dry on SNAP benefits, and that Senate Democrats are to blame for the lapse in funding. Quote, SNAP benefits will be given only when the radical left Democrats open up the government, which they can easily do, and not before, remember Trump said. This court is not naive to the administration's true motivations. Far from being concerned with child nutrition funding, these statements make clear that the administration is withholding full SNAP benefits for political purposes. Such unjustifiable partisanship has infected the USDA's decision-making, rendering it arbitrary and capricious. The court grants the plaintiff's motion for a new TRO, and the defendants are hereby ordered to make the full payment of November SNAP benefits by Friday, November 7th, 2025. The appeal. Of course, the government appealed. The Court of Appeals for the First Circuit issued an order on the 7th of November in which the court denied the government's request for an administrative stay, but promised a ruling on the merits as quickly as possible. Quote, the government filed a notice of appeal and has moved to stay pending appeal the district court's November 6th orders. The government requests a stay on the merits and an administrative stay. We note that in its stay briefing to us, the government has not disputed that it may use Section 32 funds to cover the provision of SNAP benefits for the month of November. The government had not yet established that it is entitled to a stay of both orders from being required to make full SNAP payments by utilizing Section 32 funds in combination with other contingency funds. Therefore, the request for an administrative stay is denied. The government's motion for a stay pending appeals remains pending, and we intend to issue a decision on that motion as quickly as possible. Therefore, the Trump administration must make the SNAP payments for November, while the appeal will be ruled on a different date. Enter the Supreme Court. Then the Supreme Court stepped in, and the Supreme Court, through Justice Jackson, put a hold on the case, pending the appeals court ruling. This means another few days go by before benefits could be paid. And boy, it looked bad. It looked like a liberal justice of the Supreme Court also agreed that the Trump administration could withhold SNAP benefits. But Georgetown law professor Steve Leddick sees it differently. By grabbing the chance to issue the order, instead of passing it to a larger panel of her colleagues, Justice Jackson was able to influence the timing of the administrative stay. In other words, by issuing the same substantive order that her colleagues would have anyway, a stay of the requirement to pay SNAP benefits, she kept control over an important aspect of the case, the timing of the pending benefits payments. Had she not acted, it's possible the majority of the court would have voted to stay SNAP payments until a full ruling in May of 2026. Instead, her ruling terminates the stay 48 hours after the First Circuit Court of Appeals rules on the Trump administration's appeal. This kicks it back to the First Circuit to make said full ruling. The First Circuit issued said opinion yesterday, Sunday the 9th. The appeal. Reprise. On the 9th of November, the First Circuit Court of Appeals issued its opinion on the government's appeal. Quote, a stay pending appeal is an intrusion into the ordinary process of administration and judicial review, so this extraordinary relief is never granted as a matter of right. To meet its burden for a stay, therefore, the government must make a strong showing that it is likely to succeed on the merits. But in its stay papers, the government largely ignores the enforcement order. Instead, it focuses on why it is likely to succeed in showing the district court lacked authority under the Administrative Procedure Act, the APA, to require it to expend benefits to fully cover November SNAP benefits. This limited argument is not persuasive, as the district court's enforcement order was not based on an analysis of the APA. The USDA knew at the very latest by October 10th, the day it sent its first memorandum to the states, that normal appropriations would be unavailable to cover November benefits. It also knew full well that making partial payments would be technically difficult, as it had never been done before. But it proceeded to do nothing to attempt to solve that problem over the following 3 weeks. It made no calculations, it prepared no tables, it took no other logistical steps to prepare for the shortfall. Instead, in an unexplained reversal from its 2019 position, the government announced that it would make no November SNAP payments at all because it lacked the authority to use contingency funds. Federal courts are not reduced to issuing injunctions and hoping for compliance. Once issued, an injunction may be enforced. In sum, the government fails to meaningfully challenge the district court's determination that it failed to comply with the October 31st TRO. The government has thus failed to make a strong showing that it is likely to succeed on the merits, that is, to show that the district court abused its discretion in granting the motion to enforce. The district court has now found that the government failed to comply with the October 31st TRO, from which no stay was sought and no appeal was taken that would have prevented the order from taking effect during the period of alleged noncompliance. Thus, for present purposes, the question that the government's motion to stay the enforcement order presents is this: has the government made a strong showing that it is likely to succeed in establishing either the district court erred in finding noncompliance with the October 31st TRO, or that insofar as it did not err in that regard, it could not order full funding in consequence of that noncompliance? As we have explained, the answer is no. In the single paragraph it devotes in its stay motion to addressing the enforcement order, the government does not make a strong showing of likely success in either respect, and in the only other passage of the stay motion that could be read to address the finding of noncompliance, the government fails to grapple with the actual basis for that finding. The harm from a stay would be immense. The government, understandably, makes no attempt to argue otherwise. As we have already noted, tens of millions of Americans rely on monthly SNAP benefits to pay for food. In support of their motion for a TRO, the plaintiffs provided overwhelming evidence of the harms that even a short suspension of benefits would cause, including numerous declarations from SNAP beneficiaries and those who serve them. Those declarations describe a pregnant mother in Georgia forced to skip meals to feed her son, a working grandfather in Massachusetts who would eat twice instead of 3 times a day to feed his family, a mother in North Carolina who worries about how feeding her 3 children less will affect their health, and a nonprofit leader in Rhode Island whose clients will be forced to choose whether to heat or eat as the holidays approach and winter bears down on New England. These immediate, predictable, and unchallenged harms facing 42 million Americans who rely on SNAP benefits, including 14 million children, weigh heavily against a stay. We also cannot ignore the particular events preceding this litigation. As the district court found, this is a problem that could have been avoided. The record here shows that the government sat on its hands for nearly a month, unprepared to make partial payments, while people who rely on SNAP received no benefits a week into November and counting. In light of these unique facts, we cannot conclude that the district court abused its discretion in requiring full payment of benefits to effectuate the October 31st TRO after the government failed to comply with it. Thus, we reject the government's stay request as to the order granting the motion to enforce based on noncompliance with the October 31st TRO. So where are we now? Over the weekend, the USDA issued a memo purporting to require states to make only partial payments and that future federal payments may be withheld for noncompliance if full benefits are paid. In other words, the Trump administration appears to be steaming full speed ahead with everything they can think of to withhold food from needy Americans. And why? As leverage to gain a political advantage. It's disgusting. It's un-American. It's inhumane. It's not Christian. It's not God. It's just ego, power, narcissism. a lack of emotional and mental maturity to see that he could have everything he wants, the adoration of his country, the praise of the international community, unimaginable power, if only he chose to help instead of hurt. What a waste. What a shame. But that doesn't put food in the mouths of hungry people, so I ask you to check with your local food banks and give them some cash to help them bridge the gap until the situation gets resolved. Kaylee and I donated $250 to the Second Harvest Food Bank of the Lehigh Valley, which buys about 750 meals. Kaylee has asked me to add that pet food donations are needed. Please consider donating pet food or cash to your local food bank for the pets as well. Let me know what you think of all of this in the comments below. I'll keep you updated as the courts rule and the administration continues to defy. I'm Leonard French, your favorite copyright attorney. I love you all.